My name is Joe Frick, and today we're going to be talking about how domestic violence affects the child custody determination in Idaho. Now, when the court's making a determination on who has the kids and when regarding physical custody and decisions related to legal custody, they are going to be looking at domestic violence. However, it is one factor that they're going to look at. They're still going to look at the totality of circumstances to determine who should have the kids and when. It's going to be a very substantial factor, and they're going to place a lot of weight on it, but it is not going to be the only thing that they're going to look at. So when you're going through a custody case, you can't rely on the fact that the other parent has committed domestic violence for the conclusion that you're going to get 100% of the custody just because that other parent has committed domestic violence. It's going to greatly affect that other parent's rights related to, when they get their kids, but that's not the be-all end-all. It is just one factor. It's going to have a substantial weight on it, but it's not the only factor. In addition to it only being one factor in the court's child custody determination, there's also something else that we need to talk about, which is the presumption of joint custody in Idaho. Now, the main rule is that it's presumed that it's in the best interest of children for the parents to have joint custody of the kids going forward. However, when one party has been deemed a habitual violator, perpetrator of domestic violence, then the presumption kind of flips. So when one person has been determined to be a habitual perpetrator of domestic violence, the presumption is that joint custody is not in the best interest of the children. However, judges apply this rule differently from judge to judge. Now, how much weight they place on it, that's what essentially is going to be. Because sometimes when there's domestic violence and it's not very severe, or it is outside the presence of the kids and they didn't see it, sometimes the judge will still give them custody because they feel like that they can disengage from domestic violence, the other parent versus the kids. I know that is not right, but that's how some judges apply it. So if you're going through the situation, you have domestic violence as a factor that needs to be analyzed, you need to get some professional help, because how you present that evidence and how you argue that to the judge is going to affect how much weight that is actually going to get placed on that domestic violence and how much custody that judge is going to order for the parent that committed the domestic violence is going to get. That being said, talk to a professional. If there's domestic violence, it's never advisable to go pro se on the case. Now, when there has been domestic violence in the relationship between either the other parent or the kids, you're gonna have to look at what the custody schedule is actually gonna be. Sometimes, if it's very severe, the judge will just say, nope, you, the parent that didn't commit the domestic violence, you get sole legal and physical custody because you're not placing the kids at risk of abuse or neglect. Now, and then the other parent just doesn't get to see the kids at all because he's or she is a terrible person and is beating their kids. But sometimes when it's not severe, not substantial, and the kids weren't involved, sometimes the judges will enter what's called a kind of graduated custody schedule, where there's phase 1, phase 2, phase 3. And what that typically looks like is phase 1 is going to be a certain amount of time, whether it be 6 months, 3 months, a year, depends on what the judge wants to do, to make sure that the kids aren't at risk of abuse or neglect. That phase 1 typically looks like a supervised visitation. Typically, it's going to be kids services at a facility, unless the person that didn't commit the domestic violence will agree to allow the other parent to have someone other than a professional be the supervisor. Now, that's going to be up to the judge to make that determination whether the other parent gets to have a say in it, or they're just going to order that it's going to be kids services. Phase 2, after the court is satisfied that the other parent is no longer at risk of abuse and neglect, will give the person that committed domestic violence additional time outside of supervision. Typically, that is just daytime visits for phase 2, but the custody schedule is in the discretion of the judge, so it could be whatever the judge wants. But typically, it's supervised visits, daytime visits, and after a period of time that the court deems appropriate, whether that's 3 months, 6 months, a year, of just the daytime visits, then they get stepped up to overnights. Now, whether that's just every other weekend, 1 week in a month, it's kind of up to the judge's discretion, or what do the parents agree on what they think is appropriate for each phase, to make sure that each parent's comfortable that the kids are safe in the other person's care. But that is essentially, what a graduated custody schedule looks like when there's domestic violence involved. Something like that kind of sometimes gets put in place when one parent didn't commit domestic violence, but just has been kind of absent from the kid's life for a substantial period of time, so they can kind of form a relationship. But we'll talk about that in a different video.